Good evening, YouTubers. I hope you're having a wonderful day. It's Tuesday, 8 p.m. Eastern, our regularly scheduled live stream. I hope everyone is doing great today. Down here in Miami Beach, the weather is absolutely perfect. Today probably was in the low 80s. So it's been warm and nice. I know many of you have suffered under kind of a brutal winter. I hope everybody's doing well and are keeping safe. Let me just start everything going here. The way we normally do the live stream is I have a topic to discuss. I talk about it for about 10 minutes, and my goal is to keep for 10 minutes. I've not been very good in keeping to it, but I'm going to try my best today to keep it down to about 10 minutes, after which we're just going to go free flow any questions you want to ask. So I'm going to get to every single one of your questions. So get into the live chat and just drop your question. Just make sure that before each and every question that you want me to read, respond to, or just argue with, depending on what you're trying to say, just put an @YouTuber Law, the @ symbol and YouTuber Law. On my end, it's going to show up as an orange box around the word YouTuber, which to me will mean that you want me to read out your question. Any comment you put that doesn't have an @YouTuber Law in front of it, I'm just going to skip, because normally we don't have the time to go through every single one. You don't have, I mean, obviously if you do super chat, I'll jump right to your comment, but you don't have to. All you need to do is just put @YouTuber Law, and I'll make sure to read it before the end of the live stream. So remember, this is a live stream. It's not a recorded video, so it's all about questions. So you got a question, a statement, anything you want to say, just drop it down. I will do my best to respond to it. Before we start, let's actually take a look. By the way, guys, let me know how things are, whether or not everything sounds good. Let me know if all the audio and video all sound good. So, because we've had problems in the past, I want to make sure that everybody can hear everything well. Now, let's just bring up the little poll I posted 24 hours ago. And basically had two options. Frankly, I thought I was a little surprised. I thought the Jake Paul would do better. I know that many of you are not interested in him, but the topic was actually very interesting. I may just do a video on it, but basically about whether or not Jake Paul stole somebody's video and then monetized it and actually took down the original video producer's video. It's actually very, very interesting. A lot of wrong statement made by both sides about it, so I just wanted to clarify it, but it's actually just an interesting storyline that's been taking place. Obviously, you guys are not interested at all in speaking about it, and the topic that did get, obviously, 3/4 of all the votes was about weaponizing the DMCA. And it's not as if we haven't spoken about this kind of a topic in general, or specifically about Comicsgate in the past, but not in this particular format, so should make for an interesting discussion. Let me just see what's going on at on the live stream here, on the live chat. I apologize here. Remember, guys, you want me to read everything? Everything, thank you for Crimson. Everything looks and sounds good. 10-hour loop. How are you today? I'm doing great. Thank you so much. Was looking forward to this live stream for a few days now. I haven't had a chance to drop a video. I was just busy trying to do some work, so always looking forward no matter what. I want to make sure that I do the live stream every Tuesday, so I definitely missed the interaction, so I'm doing really well. Conclansith, hello. AV seems good so far. Brian Gibson, actually going backwards in the live chat. Time to get the party started. Outstanding. Rekov, how would copyright apply to a modern reprint of old public domain architectural sketches? Can I copy the original but not the reprint? Is it different for text versus sketches? Outstanding. I'll try to respond to it after the discussion during the main event, after I speak about this particular topic. So if I forget, and I would apologize if I somehow forget about it, I'll try to remember get back to it. Luis Campuzano, hello, how you doing? Let's start the live stream. And we're back. Today we're going to talk about weaponizing DMCA for purposes of trying to fight against Comicsgate. Now, in reality, while this has a specific topic that to be discussed, in this case, Comicsgate, it's actually an issue that has been used many times in the past across a lot of different topics that brought up some controversy, right? It's just not Comicsgate. People have used for years now the threat of a copyright strike as means of actually taking down something that they oppose to. Sometimes it's because somebody's saying something negative about them. Sometimes it's somebody having an opposing idea. Sometimes you just don't like them. Sometimes it's because they're a competitor. There's a lot of different reasons. Sometimes it's for opposing political positions. Sometimes it's for social positions. Sometimes there are groups and subgroup within YouTube, and people are fighting and they are trying to deploy the tools that they have and often are reaching for the DMCA. Now, before we start, let's just get a handle on what is Comicsgate for anybody who is not certain. Basically, it's a movement that believes that the comic industry is injecting too much politics and social policies into their comics and are basically blaming a lot of those practices on the downturn in the comic book industry, the poor sales over time, saying that rather than focusing on what fans actually want, what the people that are buying your comics want to see, what they enjoy, you're focusing on greater political movements. The result is reduction in sales. So it's a set of beliefs that has come up on Twitter, Facebook, and other social media groups, and both sides have gotten very, very heated over this very topic. You would think at some level it wouldn't be such a heated topic, but in fact it has. And to me, and I apologize to everybody that what I'm about to say, it doesn't really matter. This told you before that I'm not naturally a political person. I'm not somebody that expresses his political position very often. I'm a big fan of allowing people to create what is in their mind, whether or not it's an expression of what's inside of them, whether or not they want to create things that are completely outside of the norm, they want to express themselves in a way that society does not accept, or because they are expressing themselves in a commercial way as a reflection of what their customers want. I'm in favor, ultimately, of the content creator. Whether or not the fans feel particular rights to it, or society at large feel that the content creator should act in a certain way, to me is almost irrelevant here. But everybody's entitled to their opinion. This topic, no different than any other one. And when you start reading all the blog posts and start watching the videos and the different articles on the topic, you see right away that lines have been drawn, and very, very sharply drawn in this case. This is not just some small discussion among people who are disagreeing, some civil discussion. These are people that are divided right down the middle about this particular topic. One group believes that anybody opposed to progressive ideas within the comic book industry is inherently alt-right or just hates minorities and women. The other side believes that that the injection of politics and social politics into the industry is undermining the health of the industry, undermines the value added to its users, in favor of some greater political ambition that otherwise does not materialize. And people, as you can imagine, are getting very overheated over it. Now, I think that at the heart of the issue here is a misconception here. And the larger misconception is the belief ultimately that speech is absolute in the United States. Now, don't get me wrong, we spoke about it many times. Free speech in the United States is miles ahead of just about every other country in the world. The level of protection we give to free speech is not really matched anywhere else in the world. Nonetheless, it's absolutely not absolute, and there are many exceptions to free speech. And this has come up before in this particular topic. We talked about it in diversity and comics in the past, where yes, you're absolutely permitted to express your opinions about something you're opposed to. In fact, you can, in your opinion, encourage people to buy or not to buy a certain product in protest of a company's or individuals' personally held beliefs or their policies. Absolutely permitted. You're not permitted to make phone calls directly to a business partner or a publisher and actually try to undermine an existing contractual relationship or a business relationship. Different states have different standards. Nonetheless, that is an exception to the interference with a contractual relationship is an exception to freedom of speech. And we have that many, many times. You can express yourself in very creative ways, telling people what you think of people and their politics, whether or not you're calling them NPCs, SJWs, alt-right, or just about anything you want to. Those are not going to be considered slanderous. The law will respect, however much you may disagree with your opinion, the law will respect your right to express your own opinion. Those are not factual statements. Nonetheless, if you actually go beyond that and actually express factual statements, events, and actions that took place on a specific time, the law very much can actually prosecute you for defamation based on those factual allegations. And so when we think of copyright and copyright infringement, you have to think of that as exceptions to free speech. And people don't seem to understand it. See, when the idea that people can utilize the DMCA copyright law as ways to fight against opposing opinions came out, I think that people simply had a misconception of what the DMCA was. The DMCA was passed in 2000, was actually a law that we had to pass in response to an international treaty, and Section 112, Title II, Section 112 of the law provided a safe harbor. Now, that safe harbor has almost nothing to do with content creators. It's not a way for people who create videos to somehow protect their videos from other people. It's not about the content creators. It's not about who has rights to the underlying copyrights. It's not about your rights of fair use. The DMCA has nothing to do with any of those topics. The DMCA is all about protecting YouTube, protecting Facebook. The DMCA at that point, platforms were somewhat different. But in today's world, that's what the DMCA is. It's about giving a shield from any sort of liability to platforms when they allow you to post your content. So whether or not you're posting your tweet, you're posting your post on Facebook, or you're uploading your video to YouTube, the idea is to give the platform some sort of shield from liability, because ultimately they are not really technically the publisher or the editor of that video. They're just a platform on which people actually place their own content. So it's a way of making sure that, yes, the people that are posting the videos, they will be liable, but the platforms themselves are not. And to get there, to say, you know what? How do we make sure that you as a platform is not liable for somebody posting a video that might be defamatory, that might be copyright infringement, that might pose some trademark infringement or trademark dilution or interference with a contractual relationship or anything else? How do we go about it? Well, let's set up a procedure. And that procedure basically says that you are going to allow anybody to post as long as you want to, as long as it doesn't break your own rule. You're going to allow people to post videos onto your platform. And as far as you're concerned, you're not going to remove it until you receive a letter that has very, very specific things in it by somebody claiming that they have copyrights in the material and that this particular expression of the material is infringing. At that point, you're obligated to take it down immediately. Nowadays, it can be done almost immediately. In the past, they allowed up to upwards of 10 days in which you take something down. And you'd keep it down. And you're not liable for having had it originally or for having taken it down, even if that actually causes any sort of damages to the person who uploaded that video. And you don't have to put it back up unless you receive what is known as a counter notice, in which the person who had the original video actually is claiming, no, I have a right to it. At which point you put the video back up and you back away from everything, saying, you know what, resolve it all among yourselves. The DMCA is a tool for the platforms to make sure that they are shielded from any sort of liability. Now, as you can imagine, you give that kind of a shield to the platforms, they're going to start building their rules around it. Nobody said that DMCA should be the way that videos are actually handled and copyrights would be handled. But you give the platform a chance to actually limit or absolve themselves of any sort of liability, they are going to actually copy that law and actually implement, and that's exactly what happened. Basically, from a law that was supposed to be a way for the platform to shield themselves became, well, this is copyright law. As far as YouTube is concerned, Facebook, Twitter, just about everybody, the DMCA process is copyright infringement, and nothing else matter. And so since the law never contemplated fair use as part of it, because they really weren't concerned about the content creator, they were only concerned about the platform's liability. That's why into the DMCA process, there is no real fair use process. They'll ask you if there's fair use or anything else, but it's not really part of the process here. And there lies the problem here. The people not understanding what the DMCA is are then utilizing it in order to bring down speech, thinking that they have a right to, right? Somebody speaks badly about me, what's my tool? Well, there's nothing else. Well, there is a very simple tool by which I can take it down, DMCA, lie on a bunch of the questions being asked, take it down immediately, maybe issue a strike. Obviously, the person that put it up has a chance through a counter notice to actually get their video back up, but usually that has already done some damage. But it's this lack of understanding of what the DMCA actually is. And moreover, a lack of understanding that when you actually file falsely, when you use a tool that was meant for something very, very specific, and you actually file it falsely, you're liable under federal law. Let me just show you a tiny little excerpt here from the DMCA here. And it says, any person who knowingly materially misrepresents under this section that material or activity is infringing shall be liable for any damages incurred by the alleged infringer as a result of the service provider relying upon such misrepresentation in removing or disabling access to the material or activity claimed to be infringing. Basically, it is against federal law to file a false DMCA, to use the DMCA in a way that it wasn't meant to be, that it was clearly not designed for, to bring down speech because somebody spoke badly about you, because they use your name in the title, because they might have released information about you, because you feel that they slandered you, that they maybe interfered with a relationship you have, that they are expressing opinions that are absolutely vile in your mind, that they are attacking other people, then you want to protect them. All those are completely invalid ways of for a reason. All those are completely invalid reasons to file the DMCA takedown notice, which is solely reserved for copyright infringement. And as a result, there are liabilities. And the liabilities is that the extent to which YouTube takes down a video and the individual who posted that video then suffers damages because whether or not it's AdSense or sponsorship lost or anything else like that, or in some instances when the entire channel is taken down because of successive copyright infringement, what you have, the person who actually posted that false DMCA is liable for all damages, including attorney fees. So technically, somebody can sue you when you actually file a false DMCA, because that's not what it was intended to, and the law is designed there. Now, the reason why people keep doing it is because they know that there have been very, very few cases actually where somebody was held liable for it. It's essentially, it's usually part of a greater lawsuit, somebody suing somebody, let's say for infringement, and as a result of it, as part of the process, the court finds that the very basis for filing the DMCA or for filing the counter notice was absolutely false, and they then may issue damages against the individual who filed the false filing in accordance with the DMCA. It's very rare. As far as I know, there's only been one case where that actually has, where the court actually imposed damages on the person who actually lied as part of the DMCA, and that's why people are doing it. It's a law designed for one specific thing. None of the platforms are going to change it, really add more restrictions into it, requiring proof of infringement or requiring proof that there is no fair use. None of that is going to be required, because anything that they ask more of you can potentially impose liability on them, when if they just accept the DMCA from you and take the letter, they are not actually facing any sort of liability. So that is really the reason why we have the problem that we have, and this weaponizing of the DMCA has taken place across many different topics, not just Comicsgate, a lot of different topics, and sometimes between individuals who have personal animus against one another. It's a flaw in the law itself, in what it tries to achieve, and because they provide such blanket immunity for the platform have zero incentives to actually change it, to add certain hurdles to make it a little more difficult for people to file those takedown notice. Plus, people know that while they violate federal law, the chance of them actually being prosecuted and found liable is actually very, very small. Nonetheless, let's look at the live. Forgot what I was going to say. Nonetheless, tell me what your thoughts are on the matter. Let's get into the live stream. Live chat, sorry. Let me go back. I remember there was a question here. Let me try to respond to it. Rekov, how would copyright apply to a modern reprint of an old public domain architectural sketches? A modern reprint of a public domain. Can I copy the original but not the reprint? Is it different for text versus sketches? So the answer is there is no difference between text and sketches. Obviously, if the original, whichever one is in the public domain, that's the one you can actually copy. If the reprint is in the public domain, you can absolutely copy it. If the original is, you can copy it. If one is not, then you can. Then it'd be copyright infringement. I think that's what you're asking ultimately here. If the reprint is in a public domain, it might be that the original is not. And how would that be? Because it depends on what put it into the public domain. If it's a matter of time, you know, enough time has passed and it's in a public domain, in all likelihood, the original is also in the public domain, right? Because it would have had to take place before that. But a lot of things are simply placed into the public domain, right? People, the copyright owner actually are releasing it to the public. So it's quite possible that a reprint would actually be in the public domain, but not the original. So you have to check on it, and you can then only copy whatever is actually in the public domain. 10-hour loop. How do you think Nintendo will act against music uploads from channels such as Brawl, like you saw on Twitter? They currently have over 31,000 plus songs uploaded from Nintendo. What do I think, or what do I think they will do, or what do I think their new guidelines say? Their new guidelines are pretty clear that if you upload any sort of copyrighted material from them, whether or not it's the gameplay itself, the visual or the audio, if you upload it without any sort of original content on your part, they are going to take it down, or at least they're not granting you a license as to that. Now, in reality here, what Nintendo did was realize that they were losing money, right? Because every developer knows that you want people online to play your game. You want them to stream it. You want people to record it. You want their fans to watch it. It's just free advertisement. So when Nintendo for so long was going against the trend, everybody knew it was only a matter of time, because it made absolutely no sense. If they were making some money by claiming through the Content ID monetizations of somebody else's video because it included their video game, they made pennies relative to the fact that they lost so much goodwill, plus so many other people that would have watched the video. Because what happens is, if you know that either your video is going to be taken down under copyright strike or it's going to be demonetized subject to Content ID, you're less likely to create those videos. So what do I think will happen? I think nothing will happen here, because I think that that's really is a guess on my part. You have to understand that internally they came to a realization that this was damaging to them, that this was foolish, that they were so focused on their right under copyright law, which, by the way, is not necessarily a true statement whatsoever, because there's no real proof from a legal perspective in the United States that Let's Play is somehow copyright infringement. But nonetheless, they were so focused on their own rights as a copyright holder that they missed the entire point of it, which was immense amount of viral free advertisement. So if I had to make a guess of what they will do, they'll probably do nothing, because it's a channel that promotes their games. It kind of allows fans, because who's going to be listening to Nintendo songs? It's going to be fans of the platform, whether or not for nostalgic reasons or even modern games. It's all about the fans. So a channel that keeps the fan engaged, that kind of stokes their interest in the platform and all the different games, is something that is enormously beneficial to the development. So if I'm reading this correctly, which is they made a mistake, they understand it, and now they're reversing course, it would lead me to believe that they're not going to take his channel down. But then again, Nintendo's been just about as aggressive as possible, so it could be that this will be another hurdle, and they'll fix this, 5-10 years down the line when they realize that this also was a mistake. But my gut feeling tells me that they learned from this process and now are reversing it, and will come to the realization that this idea that you have to include original content in and of itself doesn't necessarily make sense, because sometimes the most valuable entertainment you can give to somebody is streaming a game without speaking at all, just watching it, or the music, or just the audio of it. So my suspicion is that they won't do anything, but it's quite possible that 5 minutes from now I'll be proven wrong on it. Britain first. I will be publishing the lawsuit's result of our suit against Facebook very shortly. I'm aware you wanted this information for a while. Oh yes, outstanding. Do me a favor, when you publish it, just send me notice on it, maybe a DM me on it, or just, send me an email, whatever works for you, because I'd love to take a look at it. Unlucky Eddie, greeting from Frozen Hell. How you doing? Can't cleanse it. It is more an escalation of the ideological intolerance of pros against the fans. Yes, maybe I'm oversimplifying the argument here between people, but the way I see it, and it's just the problem with my own political leanings, which is largely, I don't care. We buy here in the family comics books because one of my sons, I have 3 sons and a daughter, loves comics books, but our political leaning is which comic book we buy. That's ultimately how we're responding to it, not something in terms of the protesting one way or another about the content of it. So I can see people's position. I don't have to agree with one position or the other to realize that both sides have very passionate opinions about this matter. And both sides have at times crossed the line, I would say, not necessarily legally crossed the line, but crossed the line in saying the most appropriate things in the world, and expressing themselves in the best ways. That's okay. That's just, again, that's what our system protects, our right to express ourselves whichever way we want to. It's this abuse of the law in attempt to support your position. That's where I find the whole thing objectionable. So whether or not you're trying to directly contact somebody's partners in order to undermine an existing contractual relationship, or we've seen it before, some people calling names things like pedophile that actually some courts have considered statements of fact rather than opinion, as a result can be the basis for slander, or people actually using the DMCA, what is otherwise a copyright process designed to protect the platforms, to actually bring down videos and content that has no basis in the law, meaning there is no real infringement, claiming that, well, you know, they talked about me. Well, that has nothing to do. They included my content. Be certain that if your content is included in somebody else's video on YouTube, unless it's a complete ripoff from beginning to end, it's fair use. You do not have any sort of basis on which to take down a video because somebody included any portion of your video, even if they didn't comment on it. Do you understand? Let's say I do a video and I want to talk about bad comic books, and I include some shots of a comic book. I never actually talk about that comic book or who wrote it or why I hate it. But I'm talking in the video and I'm throwing that in. That's fair use. More. Let's say I want to talk about the characters in the comic book, some comic book hero. And in the process, and I'm just talking out, I'm including a shot of the comic book. Once again, even though I'm not talking about the comic book itself or anything inside of it, I'm talking generally and I'm just showing it, it's still fair use. The problem is that 99.9% of all usages online of your content is absolutely fair use, and people feel that nonetheless they are somehow owed something, that if I'm using your content I have a right to it, or I'm owed something, or people should not be expressing themselves in a way that harms me. Well, no. They can actually harm you every single day of the week. The law actually protects their ability to express themselves in very, very creative ways and actually harm you in the process. You're not allowed to actually make a phone call to somebody's publisher and actually try to force them to back out of a deal that is actually contractual. That's an interference with a contractual relationship or a business relationship or economic relationship. There's different laws in different states, but nonetheless, you can express yourself to the public in whichever way you want to. And that's what I find most disturbing. Let people talk about their opinion. You have two sides to it. By all means, express yourself any which way you want to, even if it's in ways that some people find completely offensive. I don't see an issue with that. It's when you cross the line and try to use the law in ways that it actually was never meant, that where you actually are breaking federal law and you're hiding behind the fact that enforcement of it has been very weak. That's what I find most troubling. Wrecked Play HD. Britain First is actually a good example of two patriots who have been to jail for speech against a religion. I'm not sure what Britain First is actually a good example of two patriots. I guess I'm missing the point of what does it mean to be two patriots. Is it the people behind Britain First, the account, or is it a reference to them? I apologize. I don't understand. Let me know. Me here. Okay, wait, Leo. I just said it and say take down by mistake. Can YouTube be held to account for a mistake if they make it, or are they protected via 230? Okay, so if 230 and the DMCA are designed to protect the company, has anyone tried to sue the judges on bank for extending protection made for companies to individuals? Okay, let's talk about that. So Section 230 and Section 512 are completely different laws designed for completely different reasons, right? So on the one hand is under Section 112, which is the DMCA, that's a protection to the platform from your content. You are uploading something. You uploaded a copy of a Disney movie. That's copyright infringement. YouTube should not be held liable if YouTube follows specific steps, like it accepts the DMCA takedown from Disney, takes it down, and then doesn't put it back up unless you file a counter notice. If you do, they bring it back up. So now there's actually an infringing movie on YouTube, but YouTube is not liable because they follow the DMCA process. Section 230 is a very different. That's an earlier law that was based on the Communication Decency Act. It was an adjunct to that law, and there the protection is granted to companies in their own decision. See, the DMCA was about protecting the companies from things that they didn't do except allow you to upload, because all the liability rests with you because it was your video. Section 230 says that there be no liability for those platforms for their own actions, because frankly there is a desire to allow them to police the platform to create more family-friendly kind of environment. As a result, whatever they do online, whether or not they remove your video, they demonetize it, they bring it down in terms of its SEO, and whether or not anybody will see it, all of those actions, including also terminating your account, all of that is protected and they will not be held liable. So the question is whether or not this particular act, was it by the person posting it or by the company itself. Here we're talking about actions by the people posting it. That's why the DMCA is the right law to look at and not Section 230 here. So now you're asking, can you sue judges for extending laws that are granted to individuals to company? The answer, first of all, is no. If you could sue judges for interpreting laws in ways you disagree with, then who the hell would want to be a judge? There's always an opportunity to make a mistake, to make a bad decision. So nobody in their right mind would ever want to be a judge if there was a threat of a lawsuit. But it's not really extending the right to the individuals. Basically, the way the law is written, it's designed to protect the platform, but then set a process. So the courts then follow the process. You have to understand that a violation of the DMCA means nothing to the court as far as copyright infringement. It's a process that the court can look at. But if I don't like your video and I issue a DMCA and it's taken down, and when a court looks at it, it doesn't care at all about the DMCA. The DMCA process says nothing. Again, DMCA is just for the platform. So they are not extending the right of the platform of the companies to the individuals. It's when the courts look at it, they look at it completely holistically, saying, okay, is there copyright infringement? And they look at the four different items. We've talked about copyright infringement in the past. They go through the items. So they're actually not extending the rights to individuals, something reserved for companies. They are just looking into whether or not the process was done properly in order to extend the umbrella over any sort of liability to the company. So I think I'm hoping I explain it correctly, because the allegation is not correct. They are not extending rights that are only reserved for companies to individuals. They're just going through to make sure that YouTube, Facebook, Twitter is not liable, at which point they're just focusing on the people themselves. "10-hour loop. Interesting. I read the YouTube subreddit a lot, and often YouTube denies DMCA takedown and require more proof before they take action. What's your opinion on it? This makes YouTube liable." It potentially makes them liable, but in reality is that the DMCA is very, very specific, right? So it's written into the law. So when you go through the DMCA process, It's not called really anymore DMCA process. It used to be that. Now it's just called, copyright infringement. And you tell people what you tell YouTube what you're trying to accomplish and what the problem is, and they walk you through the steps they're walking you through. They're written into the DMCA. Literally, will say, the law says this is what people have to include in their DMCA for you as a platform to then take down the video without facing a liability. So everything was already written into the law itself here. So it's not uncommon for platforms to reject DMCA because in their reading, something is missing. Some claim some right. For instance, one of the things you have to identify as part of your DMCA is the infringing work. But sometimes people put links to either their original work or to other works that is not infringing on theirs. Meaning it's clear. They may put a link to somebody talking about how it's infringing rather than. So people make a lot of mistakes in the process itself. And as a result, YouTube is not permitted to take down the video because it's an incomplete DMCA, and that's what they're asking for. They're not asking for proof. They can't. That'll be idiotic on their part. They're exposing themselves to liability. If you file a correct DMCA and they don't take down the video, they are liable for damages you incur because for that period of time, let's say they didn't take it for 3, 4, 5 months, while they're sitting or asking you for stuff and your first one was correct, you could arguably sue them for damages you incurred because they failed to take down the video that otherwise was infringing on yours. So Google knows the game. It does not want it to open itself up to liabilities. So sometimes it has to reject the DMCAs because they're just not complete. Luis Campuzano. What happens when the original work was registered in a country as mine where the IP can only be registered for 40 years, but the work in the US is still protected? Example, Disney IP. Well, it's copyright is localized. So as far as the market, let's say, as an example, right? So we talk about Mickey Mouse. Let's say Mickey still is under copyright protection in the United States, and let's say in whatever country you're in, it's no longer. It's in the public domain because the time passed. Let's say it was already past the 40-year mark, so it was already passed. That would mean that you are permitted to do something within the jurisdiction of your country that you're not permitted to do within the United States. That is really problematic nowadays because what happens if you create a T-shirt with Mickey Mouse on it and you put it up for sale, and that means that you can sell it in your own country, but you can't necessarily ship it out to the United States. You might or might not be able to actually display it to US customers. You may have to put a geofence around the United States to make sure that people in the United States are not actually viewing the copyright infringing work, stuff like that. But it is a localized issue here, so what happens in your country can be very different than what happens in the United States. Craig King, you're getting popular enough to have haters. Success XD. Oh, because somebody is putting thumbs down? That's okay. If you read some of the comments, I get very, very colorful comments. They don't bother me at all. I find things, again, people are free to express themselves. If they find something I say or something I do objectionable, by all means, they're free to express themselves. Me here. I was asking because you mentioned in an earlier video that these actions were not intended to protect an individual person, but instead the platform was trying to see if a person can be made liable. Yes. See, well, you got it right in what I'm saying here, that the DMCA is not an indicator of copyright infringement. It's a process that would then allow the platform to not be liable for whatever we put. But it's not actually an indicator of what is or is not copyright infringement here. And that's what people are mixing up, and they're not really understanding. So if I post infringing work, I can be sued here, and it has nothing to do with the DMCA, right? Somebody can sue me for damages, for all the harm that I've done because I've posted infringing work, and it has nothing to do with the DMCA. YouTube, Facebook, Twitter are all protected, but the liability is with the individual. Now, so that never changes. DMCA doesn't change the liability between individuals. There is separate liability just for filing false DMCA. Is part of this process. There is a liability under federal law for filing false DMCA notices, but the problem with it, there's been very lax enforcement. There's been only one case to my knowledge, and that was where the individuals did not own. I mean, actually, this is relevant here because we've seen this trend on YouTube where groups of people file false DMCAs because they feel that somebody else's work is being stolen. That is a false DMCA, and you will be held liable. If you're sued, you actually will be held liable, and we have court cases to actually prove that. Why? Because there's no chance in hell that you have a right to file a DMCA because you're not the owner or the representative of the owner. And that's the only time. So there are circumstances where courts have said that filing a false DMCA would be actionable. The problem is that a lot of other tactics people are using, such as, they're not necessarily saying it often on paper, but I'm filing a DMCA because he released my information. I'm filing a DMCA because he's a jerk. I'm filing a DMCA because he's slandering me. And frankly, I don't want to engage an attorney. It's going to cost me $25,000 just to talk to an attorney and pay for the retainer. Instead, there is a free method that seems to be working. I can just file a DMCA. So technically, it's actionable by law. They are liable for filing the false DMCA. The problem is we don't see a lot of prosecutions under that. It's a lot of times it doesn't make financial sense. Think about it. Let's say you take down a video that would have gotten $5,000 worth of AdSense. That's in the millions and millions of views, a very, very popular video. Now, you think it's a lot. It's nothing, because that's less than what it will cost you to engage an attorney to file a lawsuit in it. So the process makes no sense. So even when there is liability and you're comfortable to say that you can prove that whoever filed the false DMCA knew that it was a lie and they filed it falsely with full knowledge of it, so there's not really a lot of issues. Maybe you can even show proof because they were tweeting about it, talking about it online, whatever, calling people to do that through their YouTube page. But frankly, my gauge to what I tell clients is, until you've suffered about $50,000 worth of losses, you're not going to court. You're going to swallow your losses because it's going to cost you more than it's worth. And that's the problem here, that there is no process because the law cannot handle it, because the losses are too small relative to the cost of actually filing a copyright lawsuit. It's an expensive thing. You're filing in federal court. The attorneys are rather expensive. It's going to be probably minimum of $25,000 to take a look at it. Maybe you can get an attorney to start at $12,000, but it's going to mushroom very quickly. And if your losses are $1,000, $5,000, $10,000, it's not going to make too much sense. Even though obviously $5,000, $10,000 is a lot of money, it won't make too much sense here. Excellent. I think we are at the end of the comment section. 1 second here. Okay, so I think we're over here. Guys, if you have any other questions, you want to discuss this further, you have any comments, just leave them down below. As always, what I'm going to do is take this entire stream is actually going to be taken down. I'm actually going to chop up the initial part of the conversation, reposted to the video to this channel. This entire live stream will be reposted to my secondary channel, Legal Dissent. So if you guys are interested, just subscribe to Legal Dissent if you want to watch it again or share it or anything else like that. Please give it a thumbs up. Always, always appreciated. Let me see what's going on here. Me here. In that case, can the government be sued for dereliction of duty as the DA took no interest in pursuing their due diligence and started fining or jailing for infringement? The answer is no. Incompetent government is pretty much the norm. You cannot get sued for incompetence. You know, it comes down to fraud, some breaking of the law. Unfortunately, incompetence is not illegal. 10-hour loop. I think you have never gone over the Epic Games suing Fortnite YouTubers that cheat, such as Golden Mods. Oh, I've spoken about it in at least 2 different videos. So I didn't speak about Golden Mods, but I've spoken about this whole thing, the cheaters. I've had at least 2, maybe 3 videos on it, so check it out. RMS Gigantic, your necklace is inside your shirt again. I always forget that. Yep. John Taylor, can you file a small claims dispute? The answer is yes, but small claims is going to be a state matter. This is a copyright infringement matter, which is federal, and we don't have a small claims court in federal law, in the federal legal system. This is something actually that's been proposed. I've spoken about it again. I've spoken about it maybe like a year ago. I don't remember. There was a proposal to create a small claims court within the Copyright Office. So basically it's people that would act like judges. They're not really. They're part of the Copyright Office. They're basically bureaucrats, right? Hired by the government, that if both sides agreed to it, would actually then rule on, think of it like almost like not mediation, more like an arbitration managed by the government through the Copyright Office, and they will rule and actually make determination. I don't remember what the amount was, but maybe up to 15,000. This would work. This is something that could fit if that actually went through. I doubt it. Anything is going to go through because you're asking Congress to actually go through a process of passing a law and actually having to argue between 2 sides and maybe compromise, and that's something that we really haven't seen Congress do. So I don't expect that to pass. I'm also not sure if that's such a great idea, because now you are asking bureaucrats in the government to sit in judgment of your rights and responsibilities. It probably will not be very functional. The government has its own agenda often. It's not necessarily always aligned with what the courts are saying. Do you want to submit your problem to a government official versus the court system? So it's, in some ways, it's an attractive idea to have some more sort of a small claims copyright court. I like that. I just don't know if it works. What has been proposed, where it's not going to be a real part of the judicial system. It's going to be part of the Copyright Office, part of the Library of Congress. I'm not sure if that's such a great idea. Me here. Have you heard any updates on the Google walkouts over the binding arbitration? No, I think that it's been effective. Look, I think there is ample reason to say that the concept of binding arbitration as part of employment should be outlawed. Right now, it's legal because Congress passed a law that permitted it, and then the courts are enforcing it, because if Congress wants it, the courts are not going to otherwise not enforce the law unless it's unconstitutional, and it's not really, and they didn't find it to be unconstitutional here. So the concept of binding arbitration in employment is troubling to everyone, because when you are accepting employment, some things are expected of you, like I'm not going to steal your secrets and sell it to the highest bidder. I'm going to keep all your secrets. I'm going to behave in certain ways. All that is acceptable, but the idea that no matter what you do to me, I agree never to sue you effectively and go to binding arbitration is problematic, and it's something that the courts can't do anything about. Congress has to go back and change the law that they passed a long, long time ago. So the walkout and some of the responses I've seen from other companies have largely to do with sexual discrimination, right? And I have no problem with that. I do believe that it's a huge issue, and the idea that women facing harassment at the workplace cannot sue because they're subject to binding arbitration, which allows the companies to then get rid of the offender with some golden parachute and have everything hush hush. That's definitely is a problem. I have no problem, but that's really what a lot of the walkouts and the consequence of the walkout being focused on this one issue. And I just think that there is a bigger issue beyond that that should be addressed, where employees should not be subject to binding arbitration. Period. That if you are wronged, whether or not you are, you don't get the promotion you want to because you're discriminated against for any reason. It's not just sexual discrimination. It could be racial discrimination. It could be religious discrimination. It could be because of your age. It could be a lot of different things. You shouldn't be subject to binding arbitration. So, can you just not settle in a binding arbitration and then move on to the court case? No, it's part of the binding arbitration. You agree not to take it to court. More than that, you're often then also required to keep everything secret, so you can't tell anybody. So you can't even go to the newspaper and tell them, look what happened to me. I was forced into arbitration, but this is what happened to me. So that's part of the reason why these companies want arbitration. It's going to be secret. It's going to be less costly to them, and it's most likely going to be more in favor of the company than if it went to court. They've done some studies on it and show that there's actually a marked difference in judgment when it goes to arbitration versus going through the court system, where the court system, because of how often they see people in front of them that are aggrieved, are more receptive to those claims, especially if it not only because of the judges has a certain exposure, but it actually might be subject to some sort of a jury decision as well, while in front of a binding arbitration, whether it's one individual or three. These are essentially professional judges or people in the industry, and they might be, statistically, they are less receptive to the plight of employees. 10-hour loop. Permission to post a link to a legal case against Golden Mods. I am unable to find if Epic is asking for anything from Golden Mods, only loss of sale on a free game. Sure, send it to me. I suspect I covered that from what you're saying, but absolutely post, either send me one or post one, tag me on it, whatever you like. The problem is if you post it, it's a bigger thing here. If you guys want me to cover a topic, please don't put it into the comment of the video itself, because it's going to get lost. By now I have almost 400 videos, and a lot of comments just get lost because people comment on things from 6 months ago sometimes. So if you wanted for me to cover a specific topic, Twitter. It's a far more efficient way to reach me when it comes to specific topics. You want to comment on the video, comment down below. But when it comes to a topic, or you want to share a link, don't do it through YouTube. YouTube is going to block it. You put a link, YouTube will block it. And unless I find it probably 3-4 weeks from now that it's somehow been blocked and I can find it in the spam, I won't be able to release it. So if you want to post it through Twitter. Me here. Break your silence, go to the papers and force the issue, bring the company too much unwanted attention. Right, but you could do that, but then you won't have the ability to sue in arbitration, because this is part of the rules. So, you don't want to go into arbitration, agree to a certain settlement, then break it, and then owe the company money because you violated the term of the arbitration. 10-hour loop will do. Have a wonderful night. You too. John Taylor, how do NDAs and whistleblowers law interact? That's outstanding. So everybody now signs an NDA, right? So I mostly represent companies, and every employee signs an NDA. Now, there are laws now in states that are specifically designed to protect whistleblowers, also on the federal level too. And as a result, they override the NDAs, because the NDA is just basically a contract here. So now if you have a law that says that we are going to protect people in their reporting of dangerous activities, of violations of the laws, you know, of harm being committed on other people, since all those are things that societies at large would want to know, that effectively is going to override. So the NDA is not going to protect the company. They're going to try to do that. They're going to say, look, the guy doesn't want anything to say. Basically, he's just trying to tell our secret. He's bound by the NDA. That's going to be their defense. They're not going to go anywhere because the law protects him as a whistleblower, allowing him to go to the papers, to the government, to the police, to whoever wants to report it to. Excellent. We are at an hour, guys. Have a great night. If you have any questions, any concerns, anything you want to discuss, just leave them down below. Love to talk to you. I'll see you next time.